Welcome to this explainer. Today, we're diving straight into a really high-stakes federal employment dispute. We're going to break down a fascinating legal chess match involving destroyed documents, forced overtime, and a looming trial in Patterson versus the United States Postal Service.
So, let's start with the ultimate legal mystery. What happens when the exact evidence that could prove you are wrongfully fired just disappears? Imagine you're building a case for workplace discrimination, only to find out that the very schedules, digital data, and text messages you desperately need to prove your side of the story have completely vanished from the official record. How exactly does a federal court handle a vanishing act like that? Well, let's find out.
Section 1. The Core Legal Dispute.
To understand this case, we have to establish the foundational disagreement between the employee and the Postal Service. The entire central conflict basically rests on a single document from February 2022. It's called a PS Form 2499. Now, the plaintiff claims this form was a legally binding medical accommodation for a severe back injury and that it mandated a strict 9-hour shift limit just 5 days a week. But management allegedly completely ignored this. Instead, they scheduled him for grueling 6-day work weeks, with shifts sometimes pushing way past 12 hours. And when he inevitably missed work because these massive overtime demands were breaking down his body, they fired him for attendance issues.
Section 2. Escalation and smoking guns. Now we meet the key players on the board and examine how this seemingly routine medical restriction escalated into a full-blown federal lawsuit. On one side, we have Supervisor Anthony Cisneros. His actions on the ground are really the heartbeat of these discrimination claims. He's the one who allegedly escalated the discipline, forced the daily overtime, and made some highly problematic statements. Defending the agency is Assistant U.S. Attorney Catherine Hikita. She stepped in as lead defense counsel and is currently fighting a fierce tactical battle to protect the USPS from summary judgment, which is tough to do given some glaring gaps in the evidentiary record.
The timeline leading up to the actual firing is honestly staggering. It shows a super rapid escalation. In late January 2024, Patterson is hit with a 14-day suspension for attendance. But rather than back off, management ramps it up. Throughout February and March, the plaintiff is continually forced to work well past his 9-hour medical restriction, hitting up to 12.5 hours a day. Then comes March 5th, a day that changes the entire trajectory of the case, followed by his final termination processing in April.
Okay, so what happened on March 5th? Well, it's what lawyers dream of, and what defendants absolutely dread. The plaintiff alleges that Supervisor Cisneros explicitly told him he was too old, and that they were going to remove you before FMLA hours. This striking statement forms the absolute bedrock of the plaintiff's age discrimination and retaliation claims. It links a direct discriminatory motive to the termination that was brewing right around the corner.
Section 3. The missing evidence problem. But here is where this legal chess match gets incredibly complicated, because the trail of evidence goes totally cold. Right when the plaintiff needs the daily schedules to prove exactly who assigned this punitive overtime, the documents just aren't there. We've now entered the territory of spoliation. In legal terms, spoliation is the destruction or failure to preserve critical evidence for a foreseeable lawsuit. And let me tell you, in federal court, a spoliation accusation means somebody is in deep trouble.
The sheer volume of what was lost here is what's really blowing people's minds. The plaintiff's argument points to 4 massive holes in the record. First, the DOIS scheduling data, that's the digital system used to project workloads, was routinely purged after just 1 year. Second, the actual handwritten weekly schedules were tossed in the trash after a mere 14 days. Third, critical text messages from management were left unpreserved. And finally, a formal litigation hold sent to manager Megan Williams, it was apparently left completely unsigned and unacknowledged.
Now, why do those missing documents matter so much? It all comes down to this specific date, July 11, 2024. This date is crucial because it's when the plaintiff filed his formal EEO discrimination complaint. In the legal world, filing that complaint acts as a massive red stop sign. It triggers a mandatory legal duty for the USPS to freeze and preserve all relevant records. But the automatic purges and document shredding, they allegedly just kept right on going.
Section 4. Strategic Meet and Confer.
Fast forward through over a year of bitter discovery battles to May 2026. These missing documents are now the centerpiece of a seriously high-stakes tactical showdown. Both sides are aggressively maneuvering for summary judgment. If you aren't familiar, this is essentially an attempt to deliver a pre-trial knockout blow. You're trying to convince the judge that the evidence so overwhelmingly favors your side that a trial isn't even necessary.
On May 22nd, the parties held a mandatory meet-and-confer session. Think of this as a pre-fight weigh-in where the attorneys have to talk to each other. The plaintiff initiated the call to say, "Hey, I'm filing for partial summary judgment." AUSA Hikita immediately countered, saying, "Well, I'm filing for it too." They basically looked each other in the eye, formally opposed every single one of each other's legal issues, and confirmed nobody was backing down. This guaranteed a massive head-on collision for the fast-approaching June 1 filing deadline.
Section 5, Summary Judgment Showdown.
The divide going into this deadline is crystal clear. The plaintiff wants the judge to declare the USPS liable right now, leaning heavily on Supervisor Cisneros' too old comment, and arguing that those missing schedules are proof of malicious intent. On the flip side, the defense is totally digging in. AUSA Hikita argues that the original PS Form 2499 medical restriction wasn't actually a binding, guaranteed 9-hour daily limit, and are arguing that the missing digital data was really just a planning aid, not an official record that needed saving.
Section 6, Trial Predictions and Impact.
So where does this leave us as we look toward the final stages of this litigation? Well, the docket board is currently set with 3 massive milestones. First, we have a pending sanctions ruling on the destroyed evidence sitting before Magistrate Judge Oliver. Second, we have those impending June 1 summary judgment filings we just talked about. And finally, the ultimate destination, an October 6, 2026 jury trial before Judge Olguin. Everything hinges on what happens in these next few moves.
Now, the strategic impact of this missing evidence is just monumental. If Magistrate Judge Oliver penalizes the USPS for spoliation, she could issue what's called an adverse inference. That means she would literally instruct the jury to automatically assume that the destroyed schedules and data would have proved the plaintiff's claims. If that happens, it practically hands the trial to the plaintiff on a silver platter. As we watch this intense federal docket unfold, the ultimate question remains: will the vanished evidence be the downfall of the Postal Service's defense, or can AUSA Hikita survive this summary judgment gauntlet and actually convince a jury that the missing documents were just standard, innocent operational purges? It is a super high-stakes standoff, and October 6th is coming fast. Thank you so much for joining me for this explainer, and definitely keep your eyes on the docket for this one.